Hello guys, and welcome to another episode of my lecture. This is Olayeni Dear Kolola Daniels, popularly known as Dear Co Spectre, and this is another episode of Dear Co Talks Law, where we will be talking about the 10th Maxim 10 of the law of equity, which is the fact that equity regards as done what ought to be done. Equity regards as done what ought to be done. And I've spoken about the first maxim: equity will not suffer a wrong without a remedy. I have videos on that already. Second maxim: equity follows the law. Third maxim: where there are equal equities, the law shall prevail. Fourth maxim: where the equities are equal, the first in time shall prevail. Fifth maxim: he who seeks equity must do equity. Sixth maxim: he who comes to equity must come with clean hands. Seventh maxim: equity avails the vigilant and not the indolent. Eighth maxim: equality is equity. Ninth maxim: equity looks at intent rather than form. And now our 10th maxim: equity regards as done what ought to be done. If this is your first time of coming to my channel, I want to say a very big welcome to my channel. Thank you so much for coming. Please make sure that you click the subscribe button as well as the notification bell, which is very important, so that anytime I release a video of this nature, which will be something that you are interested in, as we can see in this lecture, you'll be one of the first set of people to watch that particular video. So thank you so much. Also, do not forget to follow me on LinkedIn at Dear Kolola Daniels. Thank you so much as you do that. So let's go to our lecture for today. Equity regards as done what ought to be done. Now, the importance of this maxim lies more in the areas of property law. The division of property into personality and realty is important when question of distribution of property arises. For example, if a property is directed to be converted from one form to the other, the property in equity is regarded as converted from the moment the direction becomes effective. So if there is a trust for sale of real property and the settlor directs the trustee for the sale to invest the proceeds of sale in shares of a company, the real property is regarded as converted into personality from the moment that the trust becomes operative. The result is that the person entitled to personality on distribution immediately becomes entitled. This is called the doctrine of conversion. This is a whole class on its own, like a whole series of lecture, doctrine of conversion. But I'm just going to give you some sort of introduction so that you be able to understand what this maxim is talking about. Now let us look at it again. Equity regards as done what ought to be done. Okay, now you know that we are law students, for those of us that are in year 1, year 2, year 3, year 4, and they call us lawyers in equity. Do you know why they call us lawyers in equity? Because of this maxim. We are lawyers in equity because equity sees us as lawyers since it is ought to be done. Equity regards as done what ought to be done. Do you understand that now? So when you say lawyer in equity, lawyer and all that, and lawyer and all that, because equity sees us as being lawyers, although not in law, but because we are following the step to it, it sees us as lawyers in equity. Do you understand that? Now coming back to this, now this is in relation to property, and I really want you to calm down and listen to me. Okay, so let me give you an example. A man now is about to die, and he wrote his will, and under his will some people are supposed to collect money. That is what they call personal property. Money or anything that is not real property. Are you listening to me? Real property is land. So there are two categories of people in his will. The first category are those people that are supposed to collect money. The second category are those people that are supposed to collect land and other things. Are you listening to me? So let us imagine that you are writing a will for somebody, and you said that the first child is going to be the one to collect real property, that is land. Then you say the second child is the one that is going to collect personal property. Are you listening to me? Good. Now, before the man died, the man wrote that will when he was 70. Are you listening? And the first son, who is supposed to collect the real property, saying, yes, I'm the owner of the land at Banana Island, the one at Ajah, the one at Lekki, the one. He is very, very, very happy. While the one who is supposed to collect personal property only has clothes to collect and one very haggard car that his father is driving, and that one is looking at, hey Jesus, so now so I go come poor for this life like this, while my brother will be having a lot of properties here and there. He said, okay, fantabulous. Then because the other first child saw that he was going to be very wealthy and all that, he said, okay, that's the father. The father said, okay, fantabulous, you want to be doing my property anyhow. That one, instead of him to go to work, no, he started drinking up and down. He started doing very irrelevant things. The father kept quiet. He was watching him. When the father saw that he might die very soon, the father now called the person who wrote the will, who is supposed to execute the will, and said that, please don't change anything in this will yet, but I am giving you instructions that the moment I die, you see those properties that I've given to my first son, don't change it in the will, let it still be apparent in the will that it is his, but you see, when I die, I want you to take these instructions and convert them into money by selling them, and then using them to buy shares in company so that it can appreciate in the next 5 years, and my second son can have it as personal property. Are you listening to me? The man did not want to give the property to the second son immediately because the second son is an illiterate, the first son is educated, which is the reason the father gave the first son all the properties so that he can use it well and give it to the second son. But now that the first son has seen that all the properties have been given to him, he is now saying, fantabulous, Dubai tomorrow, Germany next day, Bahamas again, then to Poland and to Russia. Then the father said, wonderful, it is my own property that you are using to travel. Okay, fantabulous. So you think that this guy is going to go, So now, how can he help his second son who is not educated in such a way that the second son would not squander the money, or at least the money would not depreciate in the account? Then he told the trustee that this is what I want you to do. Immediately after I die, make sure that these properties, you sell them and you give the money to purchase shares in company. So let me read. For example, if a property is directed, are you listening, to be converted from one form, that is from land, to the other, which is money, that is shares, the property in equity is regarded as converted from the moment the direction becomes effective, not necessarily from the moment the direction is given. The moment the direction becomes effective. So when we are talking about the effectiveness of the direction, it is going to happen when the man dies. Are you following? So the moment the man dies, the direction, although we are seeing house, the trustee has not converted the house to shares yet, but we are seeing house. In equity, it is no longer house. In equity, it is now shares. What you are seeing is no longer house, it is now shares. Because equity sees as done what ought to be done. Are you listening? So if there is trust for sale of real property and the settlor directs the trustee for the sale to convert the proceeds of sales in shares of a company, the real property is regarded as what? Converted into what? Personality from the moment the trust becomes operative, which is when the owner dies. The result is that the person entitled to personality on distribution immediately becomes entitled. So which means that when it is now time to distribute the property, although we are seeing land, it is shares that the other party, which is the second child, will not become entitled to. Do you see that? And that That is what is called doctrine of conversion. I hope if time allows, I am going to make more series of lectures on the doctrine of conversion. But let us look at what Sir Thomas Sewell said while explaining this principle for us in the case of Fletcher and Ashburner. Now, he said, money directed to be employed in the purchase of land and land directed to be sold and turned into money are to be considered as that species of property into which they are directed to be converted, and that in whatever manner the direction is given, whether by will, by way of contract, marriage, article, settlement, or otherwise, and whether the money is actually deposited or only covenanted to be paid, or whether the land is actually conveyed, the owner of the fund or the contracting parties may make land money or money land. So what he's saying is that whatever way that instruction was given, let us look at the examples that he gave here. He said either by what? Will, or by what? Way of contract, or by what? Article, or by what? Marriage, or by what? Settlement, or otherwise, anyone it is. The moment he has said this is what is going to happen, note that the rule is, it is not the moment he said it that it converts. It is the moment where what he said becomes effective. As far as someone who gave a will is alive, the will is not effective, right? I mean, if you want to be reading my will when I'm still alive, it is when the person has died the will becomes effective. So until the statement becomes effective, for example, you gave someone money to build house, and then you said that this house, so when my son is 25, I want you to sell this house and use it to do this. If his son is 20, then the instruction has not become effective yet now. I mean, do you understand what I'm saying? Until his son is 25, immediately that instruction that they should sell the land, equity sees the land as sold immediately. Are you listening? And that is what this man is saying here. Regardless of the form, so far there has been a directive, and so far that directive now becomes effective. It's equity sees that money as land and that land as money. You can also see the case of Ogundaini versus Araba, and the case of Iragunima versus Rivers State Housing and Property Development Authority and others. Also, in the case of Wash versus Lonsdale, one who enters possession of land under an agreement for lease, of which the court will grant specific performance, is in the same position as between him and the landlord, as if the lease had already been granted to him. In other words, an agreement for a lease is as good as a lease. So this is it. Now, I went to meet someone and I said, if I want rent your property, and he said, oh, okay, no problem. How much is it? 20,000. I gave him the 20,000, but I have not signed the lease. I have not done anything. I have not even seen the document. And immediately I entered, and the landlord wants to push me out. I said, landlord, sir, there is an agreement for a lease. I made an offer. You accepted my offer, and I have given you consideration for that. In the absence of any written document or anything to show, it is between me and you, it is enforceable as the fact that equity will see that lease has already been given, because equity regards as done what ought to be done. So which means that an agreement for a lease is as good as if the lease has been granted. Do you understand? And that was what was held in the case of Walsh versus Lonsdale. The court there told us that, where you have an agreement, only an agreement, and the other party enters, you cannot push that other party out, because an agreement is as good as a lease. Also, if we look at the Nigerian case of Savage versus Soro, the plaintiff and his brother and sisters were owners of certain lands and building. The defendant obtained from the plaintiff's brother a written agreement not under seal for a lease for 5 years. The court held that in equity, the lease, though not under seal, must be deemed to have been effectively granted, and that for practical purposes, the parties were intestate, that means amongst themselves, in the same position as if the lease were valid at law and that the claim of recovery of possession failed. So this is what happened in this case. Now, one party, brothers and sisters, they have a land, and some brothers gave that land out to somebody, and but there was an agreement. The agreement was only written, and you know that according to the statute of fraud, which I told you, not only must the agreement be written, the agreement must be under deed, that is under seal. This agreement wasn't under deed or under seal, and then the other parties now wanted to push that guy out and say no, the agreement was not under seal, so it's unenforceable. The court said yes, it is not under seal, but equity regards as done what ought to be done. There has already been an agreement, and the other party has furnished consideration, which means that the contract normally ought to be unenforceable. Why? Because it was not under seal. But what we are to look at here is, was there an agreement? Because that was what ought to be done. The fact that there was supposed to be a lease, which is what ought to be done, equity will regard that there is actually a lease. Do you understand? Equity will regard that what there is actually a lease, because equity sees as done what ought to be done. So we've looked at the case of Fletcher and Ashburner, the case of Walsh and Lonsdale, and the case of Savage and Sorrow. And this is where I'll end my lecture for today. Thank you so much for watching to the end of this lecture. Make sure that you subscribe, like, and share this lecture with your friends, and most importantly, click the notification bell so that when I release a lecture video, you'll be one of the first sets to watch it. My next lecture would be equity imputes an intention to fulfill an obligation, and I will see you in my next lecture.